All right, yes, Ms. Abrams.
It's a compliance hearing.
All right, Richard Ibanez or Ibanez. Hello. How's life treating you?
Good, actually.
Okay.
I've been able to complete all the things you wanted.
I'm sorry, able to complete what?
The things that you wanted.
Okay. Ms. Abrams?
So, Judge, we're here.
Okay, compliance hearing, basically a progress report for the judge. And right off the bat, we've got a guy who's done everything right. Got housing, paid off his community service, has a job lead. But then, methamphetamine pops up. Classic 2 steps forward, 1 step back situation. And here's the key legal takeaway. When you're on probation, the court isn't just looking at whether you're checking boxes. They're looking at whether you're actually changing behavior.
For a compliance hearing, just an update from the last time he was in court. So Mr. Ibanez has made a donation to pay off all of his community service hours to the San Antonio Food Bank.
Mm-hmm.
He has secured stable housing. He has his own little apartment. His first week there, so he's been doing well there. He has a job lead, and he says hopefully that job comes through. Everything's good there. The main concern is that he hasn't been able to obtain the services for outpatient treatment through the VA.
Okay.
He is still working on that. There have been some positive UAs. That is what our concern is at this point.
All right, and positive UAs for what?
Methamphetamines, Judge.
All right, so.
He says that the methamphetamine use is not on a regular basis, maybe once or twice or every like 2 or 3 weeks.
Mm-hmm.
And that's mainly, are you his, oh, okay. Well, and that's,
Oh, that's okay.
and that's, due to self-medicating for his pain management. So since his counsel is here, maybe we can step back and talk to him. I didn't know. And then we can come back forth.
Okay, all right, thank you.
Thank you.
Sure.
Okay.
Are you,
Oh, shoot, wrong one.
are you all ready?
Well, he just kind of wanted to brainstorm.
Okay, sure. And also, did the attorney speak with you about Christian Hogan?
We didn't, the ADA and I spoke, Megan and I spoke.
Okay. All right, so on.
Ibanez, I've talked to him and his mother several times over the last months that we're doing this.
Mm-hmm.
And it does seem, she and I were just talking, it does seem like stability is increasing now.
Mm-hmm.
He was he described it as that he wasn't homeless, that he's living on the back of his car. So it sounded, yeah.
No, I think we're moving towards the right direction, but I'm just trying to figure out this outpatient with VA.
Yeah.
So what are we going to do about that?
I said he needs to either, if he can obtain this outpatient with the VA within the next 2-3 weeks, he needs to be put in outpatient through probation.
All right.
Let me show the steps that he's taking. Sometimes there's timelines that are difficult to achieve.
All right, let's bring him up here. Mr. Ibanez?
I think you stepped outside, Judge.
Sure.
Okay. All right, Mr. Ibanez. Here's the thing. I understand that you're trying to seek treatment through the VA. Everyone, please whisper. However, that doesn't give you carte blanche to use as pain medication because it's illegal. And that means that the only difference between you and somebody else who's charged with possession is that you used it before the police contacted you. And if the police do make contact with you before you use, you're going to have a new charge. Okay. So, one, are you doing any sober support meetings?
Right.
All right. So you're going to do some sober support meetings. And Do you have an appointment with the VA? Have you tried to get an appointment with the VA? What's happening with that?
Yeah, I'm working on that. Just haven't got any correspondence.
No. What are you doing what steps are you taking?
Oh, I've contacted their county liaison, the VA. She gave me a number of Endeavor and other people, so I gotta follow through with that.
No, I mean, so here's the thing. We can't just have a number and then somebody else is doing it. It's like you have to do it. This is a part of adulting.
I understand that now.
This is where Judge Boyd shows why she's so effective. She's not just scolding, she's teaching. This is part of adulting. She's breaking it down into actionable steps. Sober support meetings, a sponsor, daily calls to the VA. And the squeaky will gets the oil line? That's practical life advice wrapped in a court order. But here's the thing, she's also creating a paper trail. 3 weeks from now, if he hasn't done these things, she's got documented evidence that he wasn't complying.
So you need to pick up the phone and call the VA on a daily. This is supposed to be Military City, USA. So they should be able to get that for you. So I'm going to want you to do weekly sober support meetings. You need to get a sponsor and you're going to make phone calls to the VA so you can get in touch with them. I guess Veterans Treatment Court, can they move this along for him any quicker?
I'll call down and talk to them real quick. See if they can help.
So we're going to come back here in 3 weeks. And in 3 weeks, you better have at least 3 sober support meetings. You understand?
Yeah.
And anytime you're thinking about using, you need to go to a sober support meeting. Now, the answer you're going to get from them, don't use. You understand?
I do understand.
But you've got to start making these steps. I want to acknowledge the fact that you are making good steps, right? The apartment and everything else. But now you got to address the drug issue.
Okay.
And if that's addressed, you could be off of probation. Okay. So everybody's in agreement to sober support meetings 1 time per week?
Yes, Judge.
So you're going to do sober support meetings 1 time per week. And if you need more, you need more. That's just you figuring out what you need to maintain your sobriety. And you're going to reach out and contact the VA yourself. You understand? And when you need to call them every day. Squeaky wheel gets the oil. So call them every single day and say you desperately need help. Otherwise, when we come back here in 3 weeks, if that hasn't been done, you're going through probations. Okay? All right, I need a 3-week reset. Okay. Let me give it to you.
Copies of that?
All right. We can set it the week of August 10th. What's a good date for everybody? It can be the 10th, the 11th, or the 13th. Sometimes I can't give people choices. I give too many choices.
I was going to say, if it's up to me, just not the 13th.
All right. Then this will be recalled for August 10th.
Thank you, Judge.
You're welcome. All right. Keep up the good work. You're just going to have to push for stronger. Okay. Thank you. All right. The interpreters here. On Valeria Hernandez.
Sorry about that, Your Honor. I've been in your court before. Wasn't sure what the
That's okay.
procedures for.
Hi. Thank you. All right. So on this case, counsel, you said you received all the discovery.
Yes.
And do you speak Spanish fluently?
Yeah, pretty much. Yeah.
Oh, no, I'm asking because if you need an interpreter so you can confer with your client.
It'll
we can
probably
always
be
have an
better. Yeah.
interpreter.
Yeah.
All right. So have you had a chance to confer with her through the interpreter?
No,
You want to talk with her through the interpreter?
I think we've communicated well enough, Your Honor.
All right. Do you understand everything?
Yes.
All right. So do you need an interpreter or no?
Yes.
All right.
Para hablar con usted.
To speak with you.
Yes. But do you need an interpreter to speak with your attorney?
No.
Oh, no.
Okay. All right. So all discoveries been received. Has an offer been tendered? And how old are you?
29.
29.
All right. I need a 3-week reset for a plea deadline date. All right, so on August 17th, you need to let me know whether or not you've reached an agreement with the state. If you have not reached an agreement by that time, your next court date will be a jury trial date.
Okay.
All right, do you have any questions about anything? No.
No.
All right, just have a seat. Once you sign the reset form, you'll be excused.
Gracias.
Okay, thank you.
All right, de nada.
Thank you, Your Honor.
You're welcome.
I think maybe
Thank
I underestimated my ability to speak Spanish there.
Oh, hey, no. I always ask because,
All right, this moment is pure gold. The judge just admitted she underestimated her Spanish, and now we're getting a real human moment in the middle of a court docket. But here's the serious undercurrent. She's making sure this defendant fully understands everything through an interpreter. That's not just courtesy, that's a constitutional requirement. Due process demands that non-English speakers fully comprehend the proceedings. And when the attorney jokes about legal terms being different in a second language, that's a real issue.
interpreters are here to help.
Well, I speak Spanish as a second language, so it's not as good as as a translator. But
And then sometimes people tell me when you speak a second language, sometimes the legal terms are different. But well, good meeting you.
Nice to meet you, Your Honor. I'm sure I'll be back at some point,
All right.
probably fairly soon.
All right. Thank you. Christopher Ortiz.
May we approach, Judge?
Yes.
Haven't signed it.
Good morning. So we have a plea deadline date upon us that has been upon us since July 9th. What's going on?
Judge, we're picking up the last bit of discovery today, the CPS records. I have an order that I need you to sign in order for me to get that. And we would ask for a reset to go through that and also ask for some more time on the plea just because we need to review the CPS.
All right. This is what I tell people what I know about CPS records. They'll give you 1,000 pages, and of that 1,000 pages, only like 15 pages everything else is duplicate.
I understand.
Okay.
No, yes, Judge.
Yeah.
I think I get what you're saying.
All right. How long do y'all expect this jury trial to last? All right. I need a jury trial date, 3 days. That'll be your jury trial date and plea deadline date.
Thank you, Judge.
And it's family violence.
Yes, Judge.
Oh, I'm telling
Oh,
them
thank
it's
you.
family violence. No problem. Good seeing you.
But I do appreciate it. All right.
Thank you for dressing appropriately for court.
Thank you, Judge.
What date?
September 22nd, Judge.
All right, September 22nd. All right, are the parties ready on Christian Hoking? Court is calling 2024 CR 007778 and 2026 CR 002899, State versus Christian Grant Hoking. Could I have parties announced?
Galloway for the state.
James Hunt for defense.
And are you Mr. Ogeen? Sir, did you review the motion to revoke community supervision and cause number 2026CR002899 with your attorney? Did you understand it?
Yes, ma'am, it is.
And did you review the motion to enter adjudication of guilt and revoke community supervision and cause number 2024 CR 007778 with your attorney? Did you understand it?
Yes.
Are you the same Christian Ogeen who was placed on community supervision in 2026 CR 002899 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on March 27, 2026 for a term of 4 years? And the same Christian Grant Ogeen who was placed on deferred adjudication in 2024 CR 007778 for the offense of assault, family, household, impeding breadth of circulation on October 31st, 2024 for a period of 6 years. Is that you?
Yes,
All right, state.
Judge, will be proceeding on the same violation in each cause, not a violation of condition number 1 on or about the 30th day of June 2026 in Bexar County, Texas. The defendant Christian Grant Hogan committed the offense of evading arrest and contingent violation of condition number 1.
How do you plead to that? True or not true?
True.
will waive an amendment.
Any objections? Did you understand by pleading true to violation of condition number 1 and cause number 2026 CR 002899, the court could find it true, grant the motion, and sentence you up to 4 years in the prison and up to $1,000 fine?
Yes, ma'am.
And did you understand by pleading true to violation of condition number 1 in 2024 CR 007778, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to that violation?
Yes.
Then in each cause number, the court will find violation of condition number 1 true. Is there a proposed agreement?
No, there is not, Judge. And regarding the cause number ending in 2899, we are asking that the court grant the state's motion, revoke the defendant's supervision sentence to 4 years in the prison. And regarding the cause number ending in 7778, we are asking that the court grant the state's motion and turn adjudication of guilt against the defendant on both his supervision sentence to 6 years.
All right.
We were in agreement on 4.
Oh, okay, then.
Okay.
So then we do have an agreement.
All right, this is the big one. We've got a motion to revoke. That means this defendant was on probation, violated the terms, and now the state wants to send him to prison. And here's where it gets heavy. This is a guy with a previous conviction for injury to a child. We're talking about a history that makes judges very, very nervous. But watch Judge Boyd. She's not just rubber stamping the state's request.
For consideration, Judge, sorry.
Okay. And
4 years. Direct.
all right. And counsel, is that your proposed agreement?
That is right.
And Mr. Ogin, are you asking the court to follow that agreement?
With the agreement of running a back time or Your Honor, yes.
All right, so here's the thing. You need to listen to the questions that I'm asking you. Are you asking the court to follow that agreement you reached with your counsel? Are you waiving your right to appeal? And state you may be excused. And cause number 2026 CR 002899. As previously stated, the court is finding violation of condition number 1 true. The court will sentence you to 4 years in the prison. Give you credit for any time served. There's a $1,000 fine. Time and money will run concurrently. There's to be no unsupervised contact with minors and no residing in households with minors. And this will run concurrent with 2026 CR 002899. And that cause number, did you review the document? I'm sorry, this will run concurrent with, this will run concurrent with 2024 CR 007778. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did.
Because you waived your right to appeal, you do not have the court's permission to appeal because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Next, we're proceeding in cause number 2024 CR 007778. And that cause number, the court will find violation of condition number 1 true. Court will sentence you, the court will grant the motion, revoke, find you guilty, and sentence you to 4 years in the prison. This will run concurrent with 2026 CR 002899. There's a $1,500 fine. I'm sorry, let me repeat everything. So that's 4 years in the prison, credit for any time served, $1,500 fine, time and money to run concurrent, no unsupervised contact with minors, no residing in households with minors. This run concurrent with 2026 CR 002899. There's an affirmative finding of family violence. And there's to be no contact with to review the trial court certification of defendant's rights to appeal with your attorney. Did you understand it and sign it?
Yes, sir.
All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make better decisions. What's happening with the number one case?
I'm
Is
going to
that
go down
taken
to,
care of?
I'm going to go down to 12 right now and see.
All right, well, if he needs to be transferred, you'll have to let the deputies know.
Okay.
Thank you.
Thank you.
Shama Sanat. All right. Hello. I think we're dressing appropriately for court. So have I been pronouncing your first name correct?
Yes.
Shama, and the last name Sanat?
Yes.
Okay. What's the origin? I love different names. I'm sorry? Haiti. Okay. All righty. French speaker?
Yeah.
I love when we have the French speakers in here. Spanish speakers, take note. All right. So we're going to do the referral, and let's recall this in 45 days. And if things are done before then, let me know. Okay.
Okay, perfect.
Just follow through on everything. Okay. What date, Ms. Ferguson? All right. And just have Ms. Ferguson do that referral.
Thanks, Judge.
You're welcome. All right. Just have a seat. They'll bring the form to you.
And Judge, can we do September 9th instead of the 10th?
Oh, you have to ask Ms. Ferguson.
Oh, no, Wednesday.
No.
Oh, we can't do it Wednesday?
No.
No.
Okay, can we do it?
I can do it Monday, Tuesday, Thursday.
I love you Tuesday or Thursday. September 8th? That's a Tuesday, right?
Yes.
Okay.
Or
Aaron Rodriguez. All right. So we're back.
We're back, Your Honor.
Okay. So what's going on?
My understanding is that the state is not going to have any phone dumps in regards to my defendant or anybody else.
Okay. So there are no phone dumps?
No phone dump.
Okay.
And then the translations, there's a note that they're still pending, Judge.
So when are the translations going to be done?
Judge, my understanding is they were dropped off the third floor window for translation, but that's going to take a while. I know the TA on that.
Well, did anybody call them and ask them? Do we know where it is in the process?
I don't, Judge. I mean, I was just ordered the note today.
I'll inquire, Judge.
All right. So they're going to inquire, and then we're going to find out, because I don't want to set you for a date and then we're just here again for no translation. So if y'all step back, he's going to call and find out where it is in the process. Because if it's still at the window.
Do you need me to re-sign back in?
Oh, no.
Okay.
Just come up when he gets the answer.
Okay.
All right. Thank you. Ramiro Espinoza. Deputy Law, I'm trying not to jinx us, so I'm not going to roll my R's. I could roll my R's, but I choose not to. All right, so where are we on this case?
Well, Judge, we are at discovery, and there is quite a bit of discovery. And I conferred with the state, and we've found out some items that the state's going to look into.
So state, is there anything that you're aware of that's outstanding?
So what we're conferring about are the videos that were taken by SCPD. The update that I had for the court regarding the laboratory is that there was a gunshot residue that was taken from the complainant, but I've spoken with the lab to see if they could expedite that, and they stated to me that due to their policy, that they're not going to be processing it once it is open. It's just going to be closed out because the person that it was taken suffered from a gunshot wound, so it's not processed.
Okay,
Your Honor, may I address that?
yes.
I read a police detective's report.
Let's do this. Let's go on the record.
Okay.
All right. That way everyone is covered. So the court is calling 2026 CR 005225 State versus Romero Espinoza Jr. Could I have parties announced?
Megan Galloway for the state.
J.D. Garza defended Mr. Espinosa.
And are you Mr. Espinoza?
Yes, Your Honor.
All right. So off the record, we were talking about discovery in state. You said there's some videos from SAPD, and then there's laboratory report for gunshot residue that was taken from the complainant. And you reached out to the laboratory, and what information were you given?
Yes, Judge. So during the course of this investigation, there was a gunshot residue sample that was taken from the complainant. It was sent to the Bexar County Crime Lab. I did reach out to their administrator to get a time estimate on how long it would take to complete that analysis. When she pulled up the case to look, I had explained to her that the sample was taken from the complainant in the case, and she informed me that the lab would not be completing the analysis due to their policy that they do not complete analysis on people that have sustained gunshot wounds. And so she relayed to me that once the case was pulled into her queue to work it, it would just be closed out without analysis because the person sustained a gunshot wound. I explained the facts and circumstances of the case to her and asked her if she could conduct that analysis in space, and she said no.
Well, does an order need to be signed? Do you want the?
Well, Judge, that is where I'm opposed, because the night detectives, they understand that there's a gunshot victim. We don't do gunshot residue, so why even process it? In this case, he was processed, and so I understand their policy, but this detective already did the analysis. Now we just need the lab to process it. And that would be my objection, is that, wait a minute, my client is accused of murder, and there was a handgun found in the decedent's close to his body, and his hands were processed by the detective. Why does that policy keep the lab from completing that analysis? And I would request a court order for him to be done. Otherwise, the jury, if we go to trial, they're going to be left with a big question. What was the result of that? Because they are going to hear about the policy that doesn't allow them.
All right. So this is what needs to happen. The person who is assigned to do the testing, they need to be subpoenaed to come to court, and we'll have a hearing.
Okay.
All right. So
that would be a pretrial hearing, right there.
Yes. So I'm going to set this for pretrial, and hopefully you all let them know not to destroy anything.
Yes, Judge. They wouldn't, since the sample was taken, it would just be closed out and sent back to the property.
All right. So I'm going to recall this for hearing 30 days. Is that enough time, or you all need more?
Yes.
All right. Norma, I need a date in September for a discovery hearing.
On the Thursday.
September 10th?
Yes.
Well, I mean, not on a Thursday. We need it on a Monday.
The 14th?
All right. September 14th.
Is that going to be in the morning or the afternoon?
Afternoon.
I don't even know who that person is, Judge. Can the state notify
They'll
them?
let you know who it is. Is that not a good date?
I'm just checking what's going on.
All right. Y'all want to do it at the beginning of October?
Yeah, because I'm unavailable on the
All right. Let's put it at the beginning of October. What date? Is that a Monday? All right. October 5th. And
No.
counsel, if you'll let defense
Judge,
counsel.
excuse me, the 5th is a Saturday.
October.
Oh,
October 5th.
I'm sorry.
All right, if you'll let him know the name of the person he needs to subpoena. All right, so we'll be back on October 5th.
Okay.
All right, see you back then. Once you sign the reset form, you're excused. Thank you for dressing appropriately today.
Thank you, Your Honor.
You're welcome. Just have a seat and your attorney will bring the reset form to you. Yes,
Judge, and that's where you want to bring this up.
yes. And I'm sorry, your client is
Aaron Rodriguez.
Aaron Rodriguez.
Mrs. Espinosa is actually here now, Judge.
So,
Judge, I went to the third floor directly. I talked to the translating office. They said that Mariana Rios is in charge of that, that there is a backlog, and they tried to reach out to Mariana Rios, but she's currently in federal court. They don't know when she'll be back at what point today.
all right. Norma, recall this in 2 weeks for an update on transcription.
Let's see.
No, Norma, put it on the week of August 17th.
Could I do the 19th?
That week.
No, we can. Yes,
Okay, that's an update, right, Judge? That's what we're gonna.
yes.
Thank you. Ms. Ferguson.
August 19th.
August 19th.
Yeah.
All right. Holstein.
Yes, this is Teresa Hunstein.
Oh, just give us a moment. Defense. All right, where are we on discovery?
I've received discovery, Your Honor, and I've turned in a discovery acknowledgement.
And has an offer been tendered?
I don't think
We haven't been able to get in contact with our complaining witness. We asked for a little more time to do that. For the state to be fair.
All right, and if y'all are not able to get in contact with your witness, because it's been since June.
And to get offer based on that. Those circumstances.
All right, thank you. Norma, set this for 30 days for a plea deadline date. And is your client out of?
she lives in Georgetown, Your Honor.
Okay. All right, so you're going to need to appear in person on August 27th.
Okay.
And that will be at 9:00. And thank you for dressing appropriately, even though you're on Zoom. I appreciate that.
Yes, ma'am, of course.
All right, thank you.
Thank you. Have a great day.
You too. Bye-bye.
Bye-bye.
Okay, who is De Hoyos?
Yeah.
All right. All right, so Mr. De Hoyos.
It's Spanish, sir.
All right, can we have an interpreter come up? And what is your name, sir?
Carlos Estrada.
All right, Mr. Estrada.
Yes, ma'am.
All right, your attorney is in a jury trial in another court.
All right.
So we are going to recall you.
May I speak, Your Honor?
Yes. Well, let me interrupt you before you speak. Number one, it's probably best that you not speak about your case. So if it's anything to do with your case,
No.
if it's like a bond or you want a bond or something of that nature, it's best that your attorney be here and that you not speak to me about.
Okay. It's about bond.
What is it about a bond?
Yeah, I had to submit some paperwork for bond reduction.
All right. So this is the way the law works. When you have an attorney, that attorney would have to adopt your motion.
Okay.
All right. And if that attorney doesn't adopt your motion, then they're responsible for filing motions.
Yes, ma'am. All right.
Right. And so I'm not allowed to hear your motions since you are represented by counsel.
Okay.
So he's in jury trial. What I'm going to do is I'm going to recall you in 2 weeks. And so he should be done with his jury trial by then. If he's not, we will let you know, but I'll make sure that you're brought over so we don't lose track of you. Okay.
Yes, ma'am.
All right. I need a 2-week reset on Estrada. All right. So we'll bring you back on August 10th.
Thank you.
And then for this person, we're waiting for interpreter.
What you're gonna do is go over here and viene a sentar en la caja del jurado, okay?
Hello. All right, Ms. Garner, I'm going to give you a reset, but I don't want you to be lost in the system. All right. So what we're going to do is I'm going to recall you back in 30 days. Now, when I call you back, it's not going to appear on the system because if they're going to transfer you to the state hospital, I don't want this to hold you up, okay? But I just want to make sure that you're not just sitting at the jail, okay? Okay, thank you. You're welcome. All right, I need a 30-day reset, and this needs to be a phantom date. All right, so August 27th. So if you're still at the Bexar County Jail, we're going to bring you over. But if you're not, then that means that you will have been transferred where you need to go, okay? All right, do you have any questions about anything? All right. I hope it moves faster for you, okay? All right, good luck to you. Are you ready on Mr. De Hoyos? All right, if you all could come up. All right, so counsel, I know you probably need discovery. This is your first setting.
Yeah, Judge.
So we're going to recall you back on August 10th to make sure that he has discovery. They tell me he's in jury trial, so he really needs to be.
They dismissed it.
They dismissed it.
Yeah.
Oh, well, there you go. They dismissed his jury trial. All right, so we'll bring you back on August 10th. Do you have any questions, sir?
No.
No.
All right. All right, thank you. You're excused.
Thank you, Judge.
Can I see the state on De Hoyos?
Oh. Yes, sir.
So it's De Hoyos and Estrada.
Yes, sir.
So do y'all have any CPS records for him? Or has that already been turned over?
On the Hoyos, I believe we do on Estrada. I believe that that's up to date, unless you identify otherwise. On the Hoyos, they were ordered on June 8th. There were records ordered for all of the children. Because there are 3 alleged.
Okay, that's De Hoyos?
And I
Okay,
sent an email confirming that we were asking for all 3 of the children this morning.
all right. So just one moment.
Do we need a protective order?
Once we get them.
Yeah, but for the Estrada.
Okay, so I'm sorry, when were the CPS records ordered?
Said June 8th, that was on Malta, that was on a different case. They were ordered this morning,
Okay,
or they will be.
all right. And are there any school records?
Not that I'm aware of, but I can look into that.
All right. All right, so we'll be back on August 10th to receive an update.
Yes, sir.
And then on his other clients, you said CPS records, you all have those.
The Estrada is up.
All right, thank you.
August 10th,
Yes,
the Monday. Yeah, I'm fine.
great, thank you.
Thank you. Maybe excuse.
Yes. All right, the parties on Mandy Wallace. And did y'all confer with Ms. Abrams?
We did.
Ms. Abrams, have they conferred with you?
I just don't know what's happening.
Oh,
Okay.
I was asking about the DDRS, but no.
Okay. So have y'all,
Do I need to go speak with you?
I mean, yeah, I mean, I keep telling everybody, Vashawn is an integral part of the process. Are y'all afraid to talk to Vashawn? Are you striking fear in the hearts of men?
Yes, sir.
I always have to ask, I never asked that before, but now I have to.
But Sean is scary, Judge.
Everybody's afraid to talk to her. All right, the court is calling 2025 CR 011527 State versus Mandy Wallace. Can I have parties announced?
Christopher Simpkins for the defense.
And are you Miss Wallace? All right, Miss Wallace, you were actually supposed to be here on July 23rd. And let me just tell you what happened. The jail was not transporting females.
Oh.
I don't know what the reason for that was, but they would only transport males. And the females got left at the jail, and some came, but they came extremely late. I've said that's inefficient, but who am I? So this is the soonest we could get you here. So I didn't want you to think that we set you and we were not prepared to receive you and hear your case. So the issue with that, you'll have to take that up with the, who is it? Is this the sergeant? What's the sergeant's name? Who is the new sergeant in charge of transportation? I'm sorry, what? Yeah, you need to talk to Sergeant Jarzamek, and they can spell that for you because that's the person who should have got the females transported here today. Some reason, females, we're always at the end of lists. All right. And you are Miss Wallace. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Mandy Eileen Wallace, who was placed on deferred adjudication in 2025 CR 011527 for the offense of credit card or debit card abuse on October 20, 2025 for a period of 5 years? Is that you?
Yes.
All right, state.
Judge will be proceeding on violation of condition number 1, specifically that on or about the 15th day of May, 2026, in Berry County, Texas, the defendant, Mandy Eileen Wallace, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that? True or not true?
True.
Judge will also be proceeding on another violation of condition number 1, specifically that on or about the 16th day of May, 2026, in Berry County, Texas, the defendant, Mandy Eileen Wallace, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? She said true.
Okay.
Yes.
Judge will be waiving the remaining allegations.
Any objection?
We have no objection, John.
All right. Did you understand by pleading true to violation of condition number 1, the court can find it true, grant the motion, and find you guilty of counts 1, 2, 3, 4, and 5?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1 and 1? Court will find 1 and 1 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to revoke the defendant and sentence her to 10 months in the state jail.
Is that the agreement?
It is, Your Honor.
Ms. Wallace, are you asking that the court follow that agreement?
Yes.
Are you waiving your right to appeal?
Sorry.
You know,
Oh, yes, sir. Sorry. Yes.
All right, so here's my question. 1, has she paid the restitution to Frost Bank, $245.21? All right, and probation, what's your recommendation?
Recommendation that's on the court summary is that if the court disposes pending the number 1 cases, amend to complete the mental health evaluation to Comey in custody on 10/15/26 and follow the recommendation for it to be notified of the recommendation upon completion of the evaluation.
All right. Ms. Wallace, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record. All right, so why are you committing criminal trespass? Did you not have a place to stay?
No, ma'am. I left a friend's house that evening, and it was late at night actually. And there was a gate that was open right at the school because I was going through the school to go home. And I saw that the gate was open, and I was kind of like curious on why the gate would be open and the gate. So I went in, and there was nobody around. And I noticed that the gym was open, so the gym was open, and I let them know that I was just. It was a school, and I was.
Did you go inside the gym?
No, I did not.
All right. And then what is happening with the drug use? How often are you using?
Every so often. I mean, I just.
What does that mean?
It was weekly.
All right. So here's the thing. I'm going to give you a choice.
Yeah.
It's completely up to you what you decide to do. Probation is saying that they want you to be evaluated by the mental health unit. Have you ever been diagnosed with mental health issues?
No.
Have you ever been on any type of medication?
Yes, I have.
What for?
Zoloft and abuse, and it was for bipolar. It was for depression.
Bipolar and depression?
No, just depression and anxiety.
Okay. So 1, what I can do is I can follow the agreement that's been reached, revoke you, send you to 2 months in the state jail facility. I don't think that's really going to help you. I think the issue is you have a drug issue and you may have mental health issues, and they really can't determine your proper or appropriate mental health diagnosis if you're not clean and sober. So I can either send it to your 10 months in the state jail facility. That time is day for day, or either I can continue you and you're going to be in custody for a TAP evaluation, mental health evaluation, and the recommendations will be followed. And they may say you need to go to safety. So it's completely up to you. Which do you prefer?
I'd rather do 10 months, state jail.
Okay, I thought so. Okay. Court is finding 1 and 1 true. The court is going to sentence you to 10 months. State, you may be excused. All right, counts 1, 2, 3, 4, and 5 will run concurrently. And each count, court will sentence you to 10 months in the state jail facility. And I'm sorry, court is going to find you guilty and revoke. Court will request the therapeutic community. That's to help you with any issues you may have. It does not increase the time you're in custody, but it's hopefully to help you rehabilitate yourself and give you guidance. There's to be restitution of $245.21 to Frost Bank. There's to be no contact with Brian Vasquez. And there's to be no unsupervised contact with minors and no residing in households with minors. All right. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, good luck to you. Francisco Hernandez. Come up, sir, please. All right, your attorney is on vacation. Everybody needs some time away. What's the song with Sean? From each other? Even lovers need a holiday. All right, so we're going to recall you, and we'll recall you in 3 weeks, all right? Yes. All right, 3-week reset, please. All right, we'll see you back on August 17th. Court is calling 2026 CR 005446. State versus Tashama Williamson. Can I have parties announced?
Trey Maurer for Miss Williamson.
And are you Miss Williamson?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Miss Williamson, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
It's the document that tells you what you're charged with.
Okay.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the proceeding on the indictment as presented?
Yes, sir.
All right, and I'm gonna need you to speak up so I can hear you and the court reporter can hear you.
Okay.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with driving while intoxicated with a child under 15 years of age. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Williamson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, they have not.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is be assessed at 2 years in the state jail facility. There's an $800 fine, no application for deferred adjudication. State is recommending community supervision, and there's to be restitution payable to Norma Sanchez, if any. Did you understand that to be your plea?
Yes.
State defense?
It is, Your Honor.
That's correct, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed by are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be a term for 4 years. There be a TAP evaluation, 200 hours of community service restitution, 10 days in the Bexar County Jail as a condition, DWI intervention, VIP panel, ignition interlock for half the term, and 2-year license suspension. Did you understand that some of those conditions are statutory and some of those are recommendations from the state, and the court does not have to follow any recommendations?
Yes.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State Officer states one an attachment.
No objections.
And state any objection to the 10 days being served on GPS? All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, or review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, there were just a few things I would like to address before.
Yes.
The first one, in the court mentioned it earlier, is the 10 days. Ms. Williamson does work full-time. We would ask that she be allowed to serve on partial house arrest so she can continue to work and not lose her job from this. The second issue, Your Honor, is as far as the work is concerned, the number of community service hours, if the court would allow her to probate some of those hours or buy some of them out with proof of employment.
All right. So why were you driving with children in the vehicle intoxicated?
Drop them off to their great grandmother's, something like that.
All right. People, when they're intoxicated, they never believe they're intoxicated. So is Child Protective Services involved with you?
No, they're not
They're not your children?
they're my friends.
All right. We could have easily died that night. You understand? So I always tell people, and your attorney will tell you, I don't know anybody who goes out to drink before they start drinking saying, you know what, my plan tonight, I'm going to drink to intoxication. I'm going to have an accident and maybe I'll kill somebody. Everybody always drinks and think that they have not lost the use of their physical and mental faculties. And then they end up here. And sometimes they end up here because they killed somebody or injured somebody. And then they cry because I didn't intend to do that. But this could have turned out so much worse. And you're probably one of those people who can't drink. And I can tell you, while you're on this probation, you're not allowed to drink alcohol. Court is going to sentence you to $800 fine that will be probated, 2 years in the state jail facility, suspended and probated for 4 years, regular reporting by Zoom or in person, regular UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. There's to be restitution, if any, to Norma Sanchez. I need a restitution hearing in 30 days. All right, and you can appear for that restitution hearing by Zoom. There's to be, so do you work from home or?
Okay, physical governance.
All right, so there's to be 20 days GPS partial for work only. So that means you can only go to work and go back home. You can't stop along the way for groceries or anything like that. Waive GPS fees. Ignition interlock for half the term. Do you have a vehicle? All right, so you have to have ignition interlock on that vehicle.
I believe she has it installed already, Your Honor.
All right. 2 years license suspension. DWI intervention. VIP live. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. The remaining hours will be deducted 1 hour for every sober support meeting that is completed. And there's to be field visits 1 time per month for 2 months. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. You understand? All right, good luck to you.
Your Honor,
I'm sorry, Ms. Abrams. Add to that a TAP evaluation out of custody and follow recommendations. But if they are recommending inpatient treatment, begin with outpatient treatment.
One other question, Your Honor. Would the court consider giving her credit for the time that she has already had the ignition interlock on, or do you want it, it's going to be 2 years from today?
Yes.
Understood, Judge.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes. All right, Naja Turner. Okay, so where are we on discovery? Good morning.
I believe there's some files that need to be uploaded, discussed it with the state.
Okay. And when will that be done?
Seems to reach out to court today with the detective that handled the case to the time and said there was a risk of it. Since there was a lead foot up on the hotel, but that it was too large for them to upload some of this affairs and this for this was.
All right. Norma, recall this for 45 days and state you all will need to confer our document with the plea offer.
September 10th.
All right, we'll be back on September 10th. Once you sign the reset form, you'll be excused, okay? Are you doing okay?
I'm okay. I live in Houston now. You signed an order for relocation because of domestic violence here.
Mm-hmm.
And I was just wondering if I could zoom in for the next.
Yeah, you can zoom in for September 10th.
Okay, thank you so much.
You're welcome. All right, Xavier Garcia. All right, what's happening with this case?
Fortunately, so I'm looking comfortable with reports with self-insurance that they're going to have problems goes up to the defense. I guess we're just told that they'll get all of the survey and they want to be able to dispose it to the.
All right, Norma.
Yeah.
I need a contested hearing in 60 days.
That's September 24th.
All right, September 24th.
Thank
All
you,
parties
Judge.
need to be ready.
Okay, if there's any issues, I'll follow up with the court.
All right, and if you all decide that it's not going to be contested or you don't want to contest it, please let probation know.
Yes, ma'am.
Thank
you, Judge.
You're welcome. All right, Luis Venegas.
Have a wonderful day. Thank you again, Judge. Appreciate
You're welcome. Have a good one. Are y'all ready to proceed on the MTR?
We are.
Court is calling 2026 CR 004818, State versus Luis Francisco Venegas. Could I have parties announced?
Todd Coronado for Luis Venegas.
And are you Mr. Venegas? Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Luis Francisco Venegas who was placed on community supervision in 2026 CR 004818 for the offense of possession of controlled substance, penalty group 1 less than 1 gram, on May 21st, 2026 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Judge, we're proceeding on violations of condition number 14AA. Pursuant to the honor about the 11th day of June, 2026, in Berry County, Texas, the defendant Luis Francisco Venegas did then and there fail to attend and participate in a TAP evaluation in violation of condition number 14AA.
How do you plead to that? True or not true? Did you understand by pleading true to violation of condition 14AA, the court could find it true, grant the motion, and sentence you to 2 years in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 14AA?
Yes, ma'am.
Court will find 14AA true. Is there proposed agreement?
Yes, Judge. The agreement is to revoke the defendant, sentence him to 150 days in Berry County Jail under 12.
That's correct, Your Honor.
So why am I doing this? Has he done anything on probation?
He has been in jail ever since he's been granted probation.
Ah, yes.
Your Honor, so I got a little confused with.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Luis Venegas.
All right, you
I
may.
got a little confused with the whole, the drug court, because I went to court from, this is my first time ever doing it. And, they told me I wasn't gonna qualify because of parole. I got revoked, within the time that I was waiting for the tab. I got revoked, so, and I didn't know if, I told the, tab people that I thought it was the same thing for drug court. So I was like, I don't wanna waste our time. And since I'm getting revoked, he said it was fine. He was gonna put it on record. And as best as far as I knew that I didn't understand that. Yeah.
Well, thank you for explaining that, because I was thinking you were just violating rules, which is not good.
Yeah.
So, all right. Do you want the court to follow the agreement that you've reached?
Yes.
Are you waiving your right to appeal?
Yes.
All right. The court will find 14AA true. The court will grant the motion, revoke. And the court will sentence you to 151 days in the Bear County Jail under 1244. Give you credit for any time served. Is this a judgment satisfied?
Yes.
All right, the court will show that the judgment is satisfied and there's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because you waive your right to appeal, and because you do not have the court's permission to appeal, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you.
Yeah, every excuse.
Yes.
Thank you.
Oh, and sir, do you still have parole, or is that completed?
I'm still doing.
All right, make sure that, because parole, I used to do parole hearings. They will get you help for any drug or alcohol addiction. So make sure you go through them and let them know, okay?
Thank you.
All right, you're welcome. Good luck to you. Oh, God bless you too.
He's on page 4.
Douglas Cavender.
Judge.
Hello. You had any contact with your attorney?
I have not.
All right, this is what we're going to do. We're going to recall it for tomorrow. If your attorney doesn't show, we'll address issues, okay? All right, thank you. We'll see you tomorrow. And what page is he on?
He's on vacation.
Okay. All right, what's your name? Hernandez? You need to say yes or no. Have you had any contact with your attorney? Okay. All right, your attorney is on vacations. All right. So they're telling me he won't be back till August 5th. Norma, reset this after August 5th.
I can do the August 6th.
All right, so we'll bring you back on August 6th. All right, thank you. All right, who's this in the box?
Judge, that's mine. We're gonna need a reset on that.
All right, what's his name?
It's David Casanova.
David Casanova.
On page 4, there's a collapse.
All right, thank you. All right, Mr. Casanova, how are you doing today?
I'm doing okay, Your Honor.
Okay. State, where are we on discovery? All right, was an offer tendered?
That is correct, Judge.
How old are you, sir?
46.
All right, Norma, recall this in 2 weeks for a plea deadline date?
August 10th.
All right, we'll be back on August 10th. At that time, you need to let the court know whether or not you reached an agreement. If you have not reached an agreement, it will be a quick turnaround for a jury trial. All right.
Thank you, ma'am.
Do you have any questions?
No, ma'am.
All right, thank you.
Thank you, Your Honor.
What is happening on Byron Scott?
Judge, on Byron Scott, that needs to be a trial set.
All right, Mr. Byron Scott, come forward. Do you have any assists?
First one to actually know that. A lot of people don't know that.
You know what? A lot of people, they pretend like they enjoy sports that really don't. You know, we had a couple of worthies on the docket. And I was like, whoa. So, yes.
Some famous people. Show some actors who can.
Oh, we should. All right, so all the discovery has been received,
Yes, Your Honor.
offered, tendered, and rejected.
It's rejected.
All right, how long do y'all expect this jury trial? All right, do y'all want to come back tomorrow?
Not particularly.
I mean, we can. I'll see y'all tomorrow for jury trial.
Okay.
All right, thank you.
And then I have one more. Brad Juarez.
Page 1.
All right, Brad Patrick Juarez. Hello, how's it going? All righty. He's been set for a jury trial before.
Judge, what's happened is this is a DWI case, and I wasn't getting the discovery like I was supposed to, like body cams and all this. So the state, we've been trying to figure out what's going on. They finally figured out what's going on. Evidently, it was on Axon camera devices, and it wasn't being sent to me. So I have it. I have an offer. If you just give us maybe one short reset, we'll knock it out one way or the other.
All right, let's do this. I'm going to set you all for jury trial. Norma, set them for the week of August 17th, and then y'all can work it out then if that's what you're going to do.
Okay. Thank you, Judge.
17th.
All right, August 17th, and that will be your plea deadline date and jury trial date. You're welcome.
Thank you.
Miguel Maldonado. All right, where are we on discovery, counsel?
Well, Judge, we've had an issue with this case that was transferred up to this court, and talking with the state today, we actually figured out one of the issues, or we think we did, where it was, I guess the state had their evidence on Veripic, but it wasn't showing up on e-discovery because there was a wrong JN number.
Okay, and CPS records?
I think we have those. We have those.
Okay. All right, Norman, set this for final discovery in 30 days.
All right. Thank you, Your Honor.
All right, you're welcome, and thank you for dressing appropriately for court. What date?
27th of August.
All right, August 27th.
Thank you, Judge.
Tony, you're welcome. Tony, who do you have? I think you're the last man standing, and then we are done.
The first one, Miguel Aguilera, was a recall from Thursday.
All right, Miguel.
Aguilera.
What page is Miguel Aguilera? All right, yes, and he's not here.
He is not here, Judge.
Deputy Laura, can somebody make an announcement for Miguel Angel Aguilera?
And I did send him a text message advising him in court today.
Right. Court is calling 2024 CR 4123 State versus Miguel Angel Aguilera. Can I have parties announced?
Tony Adonis, on behalf of Mr. Aguilera.
All right. This hearing was scheduled today at 9 a.m. It is now 12:08 p.m. The defendant has not answered docket. This case was originally set on July 23rd, 2026. The defendant did not appear, and so the court recalled it for today. Have you had any contact with your client?
Not since the court date, Judge. I did speak to him on the 22nd. He did indicate to me he was going to show up on the 23rd. He did not show up on the 23rd. I've sent him a text message advising him of court today, but I've not had a response.
All right. And Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. Negative contact.
State.
Judge, we requested bond forfeiture.
All right. The court will issue a judge's warrant, remand your client without bond.
Thank you, Judge.
All right. Then let's move on to Andrea McDonald.
Yes, if she is present. Judge.
Okay. On this case, where are we on discovery?
I believe we have the discovery in, Judge. We're waiting on an offer. I'm conferring right now.
Okay. And how old are you?
I'm 36. I'll be 37.
See, once you get a certain age, it doesn't even matter. It's just like we're just celebrating birthdays. We don't need to know the ages. I have to do that all the time. All right. So, Norma, I need a plea deadline date in 3 weeks.
August 17th.
August 17th. All right. Once you sign the reset form, you're excused, and y'all can confer off docket and counsel. If you come to an agreement and you want the court to hear that today, the court will have to hear it in the afternoon.
That's fine. Thank you, Judge.
Oh, we should have a caseworker. Please,
Yeah, they never zoomed in.
I know, Your Honor, that she is in the middle of picking up or transporting a child out of state.
Okay.
So it could be that she's either on a plane
Okay.
or somewhere that she might not be able to commit.
All right. Well, I'll take whatever testimony y'all have, and then whenever she can zoom in, that's fine.
It's fine, Judge. A couple of things. Number one, we were also here this morning on a discovery on this case. And I want the court to know.
Come up, sir.
I want the court to know that the indictment's back, I think, in February. I've been trying to get discovery, and the intake has been telling me it would be on Veripic, and it was never there. As a matter of fact, as of July the 5th, there was nothing on Veripic. I went back to Hugo Sanchez, the intake prosecutor, and he didn't have it. He was finally able to get it, and now he's downloaded on a passport that I've given him. So about 10 days ago, I got the passport. There's tremendous amounts of documents on it, so I'm not anywhere near. And I assume I've got it all. I don't know for sure, but I know I've got tons of it to look at. So that's where I am in discovery.
All right. So, Norma, on this case, give me a discovery date in 60 days. All right. So that's the discovery date. And then
September 24th.
Before we go on the record, do you have the motion to modify?
I do.
All right.
I've got it too. Well, yeah.
Okay. I have it. I
Okay.
just want to make sure everybody is on the same page. Court is calling 2026 CR 007780 State versus Ryan Daniel Martinez. Can I have parties announced?
Will Van Zieten for the state of Texas.
And Ron Ross for Ryan Martinez.
All right. And are you Mr. Martinez?
Yes, ma'am.
All right. We're here on a motion to modify bond conditions. Defense, what are you asking for?
I'm asking for the judge to reinstate his access to his children, visitation rights with his children that were afforded him from June last year until February of this year. The incident that we're here on today happened in June of last year. CPS got involved. They had hearings. There was a court-ordered visitation scheduled for him for his children in through the CPS court system. And once he was indicted in February, CPS cut off all of his access to his children. And we're here today to ask the CPS, I believe, and his lawyer will testify, and I think the caseworker would testify also. CPS actually wants him to have a relationship with children, wants and encourages that the no contact order that was issued whenever he was indicted by a magistrate judge, that be rescinded, that he be reinstated his previous visitation rights with his children. They were all supervised, and they were all held at the offices of the Child Protective Services.
All right. So here's my question. The children that he that the no contact order is with, or is it the twins or the surviving twin?
Transmission.
So are there other children?
There's two older children.
And what are their ages?
6 and 5.
And I'm sorry, could you announce your name for the record?
Yes, Your Honor, my name is Rosie Reyes. I'm the court-appointed attorney on the CPS case.
Okay, and you're the court-appointed attorney for Mr. Martinez?
Mr. Martinez, yes.
Okay. So. What are the ages of all the children?
We have Mavis. Go ahead.
Mavis Martinez.
Oh, I'm sorry. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Ryan Martinez.
All right, so I'm not going to ask you about any of the facts of this case. I'm just trying to get the ages of the children. And then if your attorney wants to ask you some questions, he can do that, okay?
Yes.
So I don't need the children's name. I just need the ages of all the living children.
6, 5, and 1.
All right, and the 1-year-old is the surviving twin?
Mm-hmm.
And the case that we're on here today, is that related to the twin?
To the deceased child.
Yes.
Okay.
You asked about, I don't know, if here was the no contact order, the magistrate's order. It only addresses the two small children, I think, but CPS has cut off all his visitation to all his children.
And Your Honor,
Yes.
for your information, I've asked the child's mother, Valerie, to be here as well. If you have any questions for her, she is available.
All right, thank you. So the child that's listed in the no contact order, that's the surviving twin?
That would probably be both of them, Mia and Maya.
Well, they only have one name in there.
They are very similar names, unfortunately. One is Mia, M-I-A. One is Maya, M-Y-A.
I think that one has Mia
It only has
listed.
Mia.
Yeah, and Mia is not the surviving child.
That's a deceased child.
So where is the note? Because that only has that child's name for the no contact order. So
You're right.
yes.
Immediately after this happened, I had a motion for visitation because they stopped the visitation because of the no contact order. And then the DA, I believe, modified it to include all the children.
Would
At
that be
one point.
the CPS prosecutor?
No,
The criminal?
yeah,
All right.
because the CPS prosecutor wouldn't do that.
My understanding, the CPS will not let him have visitation unless this court orders that he can have visitation with his children, the two older children and the one surviving smaller
Well,
child.
I want to see where this other motion is. Just 1 second. All right, somebody sign a pretrial motion to modify conditions, and that had to do with working.
I did that earlier this year.
Okay.
This would have been last year sometime if through the CPS, they would have had a different case number too.
Okay. All right, we're off the record for a couple of minutes because I know we're going to start having a conversation over each other. All right, I'm trying to find to the clerk. Can you pull where somebody, thank you. So let's find out where this order is, who signed it, what it's about. But I am going to have to take evidence if it's an order in place and you all are asking for that to be changed. And then we'll go from there. She's going to pull it. And State, are you going to be objecting to this?
We are, Coach Your Honor.
Okay. And parties, when you all have your arguments or whatever evidence you want to present, bear in mind, I know absolutely nothing about this case, only what's in the indictment. Oh, okay. Do we know which judge this was?
We've been judged on that.
Ah,
Oh, no.
okay. Alrighty. Now I see, we can go back on the record. So I am looking at the motion to increase and amend bond conditions. And this was signed by a judge on February 9th, 2026. And then that judge ordered no contact with all of the children. All right, now that we have that out of the way, the court will take any testimony. Defense, do you have any witnesses?
I would call Rosie Reyes.
All right. You're an officer of the court. You don't have to be sworn in.
If you want to state for the record what your name is.
My name is Rosie Reyes. I'm the court-appointed attorney in Mr. Martinez's CPS case, Your Honor.
And you've been his attorney since almost the beginning of the CPS matter.
Since the 262 hearing.
And that was back last summer, maybe June or July?
That was last summer, yeah, between June and July, yes.
And the child is deceased, that's the subject that caused all this, is she died in June, correct?
Yes.
And so after you became the lawyer, y'all eventually went to court and there was an order for his visitation rights?
Yes, but as both parents get supervised visits, Your Honor, and both a mom and dad got supervised visits.
Yeah, what was his supervised visitation?
His supervised visits at the time that they stopped were weekly with his children, his two oldest at the CPS. It's monitored. It's in the CPS facility. His youngest child was in Killeen, Texas, in a foster home that had a nurse as a foster parent because she suffered some medical, she had a medical procedure that at the hospital that caused the result of the tearing of her larynx. So she had a lot of medical issues. So they placed her in Killeen, and he would visit twice a month in Killeen, Texas.
And for how long was his visits when he went?
In Killeen, because of the travel time, he had 2 hours. And here in San Antonio, it was an hour.
Here in San Antonio, it was weekly?
It was weekly, yes.
1 hour each week supervised here, and there it was 2 hours twice a month.
Yes.
And has there been any problems to your knowledge of visitation? Has there been any reports that they didn't work well? There's been a problem at all?
Your Honor, I've reviewed all the monitor's notes for every visit for all the children, and he is exemplary when it comes to his visitation with his children. So in a CPS case, when parents visit, they have to provide food, they have to provide activities for them during that period of time. They have to show appropriate parenting skills. Each and every one of his monitored reports by the monitor are excellent. In reference to his child in Killeen, the same thing. He was visiting, his mother was also attending those visits. So there was no complaints whatsoever with his visitation with his children.
And I want to make it clear the visitations were supervised at the offices of the Department of Regulatory Services, Child Protection Services, right?
Yes, and in Killeen, they had a special place. They had a visitation center that she would be taken, and that's where the visits were. So the foster mom would also be there and was in contact with him on a regular basis, I believe.
Okay, so let me ask this. So the order for visitation was changed on February 9th, 2026. Before that order was signed on that date, was he previously having the supervised visitation?
Yes, Your Honor.
And how often had he had supervised visitation?
He has not missed any visits since the 262.
Since last July, perhaps, through until February?
Yes, so visits, as you know, there's a staggered before they start setting up. He has not missed any visits with his children.
So this is what I can tell parties what I want to understand. Number one, what is concern about supervised visitation? Because I can tell both parties, based upon the information that I've read and the motion to modify conditions and the motion to increase and amend bond conditions that was filed by the state, I'm not doing a unsupervised
this is
visitation.
We're not asking for, I've asked for supervised.
Yes. So then the issue becomes, what is the issue with supervised visitation?
Your Honor, the state is opposed to it for two reasons. The first is a general
concern the state has with any sort of visitation moving forward, which is that this defendant has previously been convicted in this court of causing injury to a child who received 18 months in the state jail from this court. That's a general concern that the state has with any sort of visitation. As to the supervised visitation, the representation of the children's mother who's here in this court, she's indicated to me that the children do not want to see the defendant as part of visitation. I understand that the family court will order visitation whether the children want it or not frequently. However, the state believes that if the children do not want to see.
Well, I will tell you, part of the issue that needs to be addressed then is, what does the child's ad litem, what do they say?
Mrs. Stout, I am uncertain at this point. I'm assuming she's also opposed to having visits, but at the 262, all this information about his prior case was known. Visitation was not restricted at that point. And he was having visits on a regular basis and doing the visits. So there was no issue up until the criminal case was finally filed against him. And at that point, talking with the CPS prosecuting attorney, the only reason that the visits weren't happening is because of the criminal case. So it wasn't their fault that the visits weren't continuing. It was the prosecutor in the criminal case that was hampering that. And so this is where we're at now. So every time I file a motion for visits, they go, well, Rosie, it's not us that are stopping these visits. It's the prosecutor here, or it's what's noted that's stopping the visits. And that's the only thing that's stopping the visits.
Couple of more questions.
Yes.
The children are not living with the mother, are they?
Not at this time. They are. The goal is to reunite the children with mom. The youngest child, who was in Colleen, is now here with a relative. I believe it's her aunt. And she has not yet, I think, been placed. So mom's had extended visits. I'm not certain how well those visits are going and how frequent those visits are. She does not have the youngest one that has special needs, requires a special bed, requires special feeding because she's got a feeding tube. And so when that transition is going to happen, I am uncertain.
Well, another question. You know, the caseworker on this case, what's her name?
The caseworker is Lisa Gaines Brooks.
Educate me. Is she the caseworker for the children? All parties? Who does she casework?
She represents CPS. So obviously, I always tell my clients, she is always looking out for the best interest of the children. At the last staffing that we had, or the last court hearing we had, they're not seeking to terminate him. Like I said, he's an exemplary dad. There's no indication on any of the records, and I reviewed them because I take it very seriously when this has happened. And there's nothing in there that says that he has been inappropriate, that he is not prepared when he visits with his children. I think there was only one time, his little boy is very energetic, so he likes to horseplay. And the monitor said, let's not do that. And that was the only time over the numerous hearings, visits that he's had with his children.
Does the caseworker, to your knowledge, does she have any objections to reinstating visitation?
The caseworker doesn't have any objections. And as talking with the ADA in this the case, she said, "It's my hands are tied because."
Who's the ADA?
It's Sarah Spears. Sarah's last name.
Let me ask you this. Is there?
I'm sorry. I just, after a while, you just.
Yeah.
You were talking about terminating rights. Is there a concern if he doesn't get his visitation back that the CPS may move to terminate his rights?
So at this time, we were set to go to trial. We have a jury trial that was set for August. That has been extended. It's been extended to get the children placed eventually with mom and the little one placed with mom. So they're giving her more opportunity to have that happen. And so that's why we went to like a pre-settlement kind of conference. And at this point, like I said, Your Honor, the CPS and the caseworker are not seeking to terminate.
All right.
How about his rights? They were seeking to terminate his rights?
Yeah, they're not seeking to terminate either one.
Would that be a possibility if he doesn't get his visitation rate?
The problem is he hasn't had his visits in the last 6 months. And those visits, the children look forward to him every week. Now, I understand mom is going to say, and I've heard it in court, that the kids don't want to see him anymore. But he's been denied access for 6 months. They were placed with the grandparents, the maternal grandparents. So I do family law, you know how that goes. So,
This right here is why Judge Boyd is one of the most thoughtful judges you'll ever see on the bench. She's handling a motion to modify bond conditions so this father can see his kids again, but she's not rushing to judgment. She's got concerns, a prior conviction for injury to a child, and she wants to hear from the therapist, the caseworker, the neutral parties. She's basically saying, I need to know what's actually best for these kids, not just what the lawyers want.
My honest feeling is that once they have visits, the moment they see each other, it's going to be fine.
I'll pass the witness.
So the current goal of Department of Family Protective Services is family reunification.
Yes, it is.
That can change.
It obviously can change.
And frequently when they seek termination, they have the goal of family reunification up until the point when they decide to seek it.
Yes and no, because this case was extended, it's reunification. And it's been reunification since day one.
No further questions.
Just one question to my client. If I don't want to get, we're not going to get into.
Well, I mean, before you do that, so are they looking at joint managing
No,
conservatorship?
No.
But
what we
managing and
she will
possessor?
become sole managing of the children, and he will be possessory. His visitation, even afterwards, we've agreed that they stay supervised until this criminal case matter is settled one way or another.
Okay. Right. Thank you so much.
You're very welcome, Your Honor.
I'd like to ask my client one question.
Sure.
You want to swear him in or not?
Oh, I sworn him in.
The prior offense that you had that you went to prison for, what was that about? It was a baby, right?
Yes.
And what happened there, just briefly?
I was just taking a shower with her and she slipped out of my hand.
And she was how old?
She was 2 months.
Okay, that's all. Pass the witness.
But you were convicted. You pled true, no contest or guilty to the offense of injury to a child causing bodily injury to recklessness, and you served 18 months in the state jail facility.
Yes.
So all the witnesses, Judge.
All right, so let me just tell the parties what my concerns are. And
Can I tell you one thing?
Sure.
The order that was, I guess it was signed by this court in February, Daryl Harris sent me a copy of that.
Oh, no, I didn't sign the order. Someone else signed it.
Daryl Harris sent me a copy of with the motion to set. There was never a setting on it. I was never given notice for the setting of that particular hearing on that thing.
Yeah, this is not my handwriting.
Well, okay, but I was never given a notice of a setting. So it was signed without notice to me.
Because I always give everybody notice.
Yeah. I was kind of surprised.
Yeah, and Your Honor, I was surprised because there was just a change and he was having this visits. We actually had a CPS hearing during that time.
All right, so these are my concerns, and maybe you all can address them. And maybe it's addressed through different witnesses. Number one, I am concerned about the fact that he's been to prison, well, to the state jail facility before for injury to a child. So I would like to refamiliarize myself with the stipulated evidence in that case. Then my other concern is, and I know you're an officer of the court, and I've known you forever, but the child's ad litem, I would really like to hear from them because they're 100% supposed to be looking out for the best interests of the children, and they're the ad litem. And I would like to find out from either the person who supervised the visitation or either from the therapist of the children to see if the children really want to see him. Some people are going to say no, they're afraid of him, they don't want to see him. And maybe some people will say yes. Disinterested party, well, I should say the party who should not be biased would be the therapist or whoever it is. So I would like to hear that, and then I can make an informed decision that hopefully protects everybody.
Can we reset that for maybe next week or?
You all just discuss on when this can happen, and any objections to anybody appearing by Zoom, because I know caseworkers and therapists are very busy.
No, I have no problems.
All right, so this is what I'll have you all do. He's set on the docket in September for discovery, but of course we want to do that before then. So if you all will discover when these witnesses will be available, and you can put it on the docket whenever you want to put it on the docket, and I'll make sure I'm here.
Okay, does the clients need to be on present, or they do it on
Oh, they can
Zoom
be
too?
present, or they can be in Zoom or Zoom, however, what is easiest for either party.
I can be on Zoom or in present, Your Honor. It just depends.
Okay.
So if you guys just figure out a date when everybody can be here, and then I'll make my decision.
All right.
Your Honor, would it be helpful for you to see the certified notes for the monitor, or do you want to speak to a monitor? Sometimes they have different monitors.
Yeah. Oh, I tell you what, if you all will review the certified notes, and then if y'all feel like I need something more than that, let me know. I keep an open mind.
But you primarily want the therapist and the ad litem.
Yes.
Your Honor, as to the stipulations in the prior case, that was out of this court.
Yes.
I'll be able to find those stipulations, present them to this court.
Yes, and also to, yes.
Okay. That'll work. That'll work.
He doesn't object.
Okay. Awesome. All right. Thank you, guys. Oh, and once he signs the reset form, he'll be excused.
She signed it.
And you all just let Norma know what's a good date for everybody to be available. All right, Mr. Roscoe, if you'll come down. All right, Mr. Roscoe, how are you doing today?
I'm doing okay. How are you?
I am doing great. I can't complain. All right, so they're telling me your attorney's in federal court. Federal court takes precedent over state court. Have you had a chance to speak with your attorney?
I have not.
Have you ever spoken with him?
Never.
Just 1 second. Well, I think this may be your first sitting with this court. So what we're going to do, we're going to recall you for tomorrow. If he's not here, then we'll address it. Okay. All right. Thank you.
I can't be appointed another attorney at this time?
Well, we're going to recall it tomorrow.
Okay.
We're going to see if he's here. And then if there are issues, then we'll address it at that time.
Thank you.
You're welcome.
All right, come on.
Then we have Michael Hill. All right. This is a motion to suppress.
Yes.
All right. Are parties ready? Okay. And defense, before we go into record, what is the issue? Is it the stop? Is it a search? What's going on?
We believe it is a search judge. We believe that there is an unreasonable delay between the stop and the search. So we're just challenging reasonable suspicion for that.
Okay.
For the search.
And is there a warrant involved or no?
There's not.
Okay.
And Judge, we'll stipulate that's a warrant surprise.
Okay.
Well, I think it's a warrantless search. We're not challenging the arrest.
Okay. All righty.
For whatever that's worth.
All right. Thank you.
Thank you.
All right. Is your client going to take a seat?
Would you like him to?
Sure.
Yes.
And counsel, the search, was this a vehicle?
Yes, Judge.
Okay.
I'm sorry.
Yes. Judge, can we have our witness on the stand?
Oh, and let me know when y'all have the motion. All right, court is calling 2026 CR 001939, State versus Michael Hill. Can I have parties announce?
Yes, Judge. Brandon Prater and Lauren Espinoza for the state.
Jason Todd and Victoria Hassett for Mr. Hill.
And are you Mr. Hill?
Yes, ma'am.
All right, we're here for a motion to suppress off the record. My understanding, sorry, we're on the record. But off the record, parties stated that that this was a warrantless arrest and search.
Yes, Judge.
And state, you said you're stipulating to that?
Yes, Judge. We'll stipulate this was a warrantless search. The burden has shifted. We're prepared to proceed.
All right, state, you may proceed.
Thank you, Judge. We'll call Officer Andrew Vasquez instead.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so everyone can hear. If you'll state your name for the record and spell your last name.
Andrew Vasquez. Last name Bacquez.
All right, state, you may proceed.
Thank you, Judge. Good afternoon, officer. Can you say for the record, what law enforcement agency are you commissioned with right now?
Universal City.
Okay. Were you commissioned with Universal City Police Department on July 17, 2025?
Yes.
What were your duties on July 17, 2025?
Patrol.
Okay. Can you go through? What would you?
I'm just looking for my highlight.
Okay.
You're totally different for me.
Okay. All right, officer. Did you perform a traffic citation that night?
Yes.
Did you write a report based on that traffic stop?
Yes.
Would a copy of your report help refresh your memory?
Yes.
You already have that report in front of you?
Yes.